Good morning. Thanks for joining us today. I am presenting with my colleague Justin Webb this morning on cybersecurity risk management, and we tried to make a cute title of it by saying technically challenged. But I will tell you that by the end of this presentation, I hope that you'll feel more confident that as in-house or outside counsel, you have a better understanding of what you can do back with your organization as to how to manage this type of risk. I am a testament to the fact that you do not have to be a techie in order to understand this topic and actually make some real change for your organization in terms of protecting it from the risks that it faces. My colleague Justin is really our secret weapon. He was an information security officer for Marquette University before joining the practice of law, and definitely I think it helps to have someone who can translate all the IT stuff for you. But again, as I said, this is something that everyone can understand and take care of. I think that I have data security is not just for plans and providers anymore. Given that I work in the healthcare department and chair our health and hospital system practice, obviously HIPAA is a big part of what I do, and it does impact primarily plans and providers and entities called clearinghouses. But cybersecurity in the last 5 years really has grown so broadly. We've all seen the breaches of Home Depot and Target and big name companies that we're familiar with. And I think people are starting to realize that their data it really is a tremendous asset to their organization, and it's critically important that you understand as counsel what risks your clients or your organization is facing and deal with them. I think that the other thing I would say is that states have really gotten involved in this quite a bit. State attorney generals are very concerned about consumer information. We also see the FTC recently trying to spread their wings a bit into this territory from a consumer protection standpoint, and they're starting to get involved in the regulation of data security, which is kind of a scary trend. I think that it is complicated in part by the fact that industry standards are hard for any particular organization to pin down. I think there's wide variance both within industries and across industries, and this is something that is very hard to benchmark against your peers. I think there's not a lot of public information out on this. You know when it goes really bad, but you don't know when it's going well, if it really is going well or it just isn't their turn yet. I think that the other thing I will say is that a lot of organizations have entered knowingly or unknowingly into various contracts that obligate them to very significant protections for data that they may or may not even have fully understood. A lot of organizations don't have a contract review process that includes a subject matter expert or even their own IT department. IT departments are typically very strapped for both body resources as well as time, and it makes it really hard to make sure that from a legal standpoint your organization has only agreed to that which it really can perform. I think that in terms of enforcement, we're only going to see an increase in enforcement by regulatory agencies. And really, last but not least, the most significant threat to your data really isn't the evil hacker or fancy bear, or I don't know, for those of you who know all the names of these various international hacker organizations. It's really could be your employees, your boots on the ground folks who are just doing their job day to day, often can present a very significant security risk if that isn't well managed. So we're going to talk about, briefly, I'll talk about the types of data that need to be protected, because I think a lot of times people think, oh, that's just healthcare. And we're going to talk about 5 cyber best practices that I think are very easy to understand, and all of which are things that you can go back and kind of benchmark yourself or say, hey, we ought to be thinking about this, or what are we doing in this category? So I hope this is going to be useful for you. I really think it's critically important. I just got done giving a presentation on the Department of Justice's focus on individual accountability, and I think that that really is something that rings true for this too. It's really important top down as well as bottom up that organizations focus on cybersecurity risk. Justin's going to talk about the various security frameworks that organizations can put into place, and I will tell you the government's framework, the NIST standards. Actually, if you look at those, only 22% of them are really owned by the IT department. All right, so 78% of the controls are really outside the control of the IT department, and those widely range throughout the organization. So if you think that this is purely an IT problem, I would posit that you're probably not adequately managing your risk. So you need to engage your board. You need to do the hard work of coming up with your risk management strategy. You can't do that until you've assessed what your risks actually are. Where are your gaps? And which of those gaps really deserve the highest level of priority in terms of addressing them. And that process of going through the risk analysis, what are the risks to our data assets, and what is the relative level of control that we currently exercise over that asset, and where do we want it to be, critically important. I think that preparing for a breach, it's not a question of if it's going to happen, it's really when. And advanced preparation is really critical if you're going to be able to manage something in the most cost-effective, efficient, and effective way. Really important to have a process in place to manage your vendors and your contracts. I very often see agreements that clients have signed that far exceed security controls that they even understand, let alone actually have implemented. And on the other side of it, I'm amazed at the number of times that people have failed to recognize that they are actually selling their data. Oftentimes you have software programs that are given to you for free. Well, if it's for free, it actually is that you've agreed to provide your valuable data to someone. There's a reason that they're giving something of value to, or a software program for free. It's really not for free. And I think what you're paying for really may or may not be on par with what you really intended to get. Really, really important that you understand who is using your data and what they're doing with it, because frankly that can really splash back on you. And last but not least, the obvious, to train. But I think oftentimes people misunderstand the real or perceived threat may not be the real, the actual threat, which is your employees day to day who might answer phishing scams or other things that can really attack your network. That is what I really want you to be thinking about. So what kind of data must be protected? PII, kind of a term of art, something that you're going to see very frequently in a lot of state laws. That's personally identifiable information. Depending on the state, it includes everything from just basic demographic information to social security numbers, driver's license numbers, other state ID numbers, any financial account numbers, accesses, passwords in some states can be deemed to be PII. Some states even expand PII to include medical information, health insurance information. So this is entities that may or may not be in the healthcare industry that may maintain this information. And I'll give you the example of workers' compensation or life insurance. Those are both organizations that maintain and receive a lot of health information that are not covered by HIPAA, but are subject to many of these state laws. Any kind of a financial, anyone who has credit cards, accepts credit cards, is receiving PII. And we're not going to talk about the credit card industry standards for protecting data today, but PCI compliance is something that is, while not mandated by law, certainly something that you need to be doing if you're allowing people to pay for your services with credit cards. PHI, this I see written in so many different ways. It is protected health information, not personal health information, protected health information. It's a defined term under the Health Insurance Portability and Accountability Act, which was actually enacted back in 1996, quite some time ago. When it was first enacted, it covered plans and providers and clearinghouses and required those entities to enter into contractual agreements to protect the PHI that they share with their vendors. now those vendors, which include law firms, accountants, actuaries, are actually directly subject to the security provisions of the law. So those provisions that govern electronic health information directly apply to folks who deal with this information in their day-to-day business transactions. So examples will be your claims data, health plan data, registration data, demographic data. If it is in the hands of a covered entity, it is going to likely be PHI. This is something that I think is really widely misunderstood. I've gone through debates with numerous corporate clients, software vendors, people who are developing products that are going to assist organizations that work with health information, and it really, it's always surprising to me. PHI or PII doesn't lose its status as such simply because you are not a covered entity. So if we receive, or a vendor receives, the health information of a customer, and they're using that information to benchmark for that customer, to provide a service for that customer, to transmit data to another third party, that information still must be protected under the law. And merely because your organization is not directly subject to these laws doesn't mean that you don't have obligations and significant liability if you don't protect it. So I think that that's really important to keep in mind. The second thing is that a lot of people believe that if I merely remove someone's name or their social security number, that I have de-identified data and it's no longer individually identifiable. And in this day and age, with the huge amount of information that is publicly available about individuals, just generally to the public on the internet, it's really important for you to understand that merely spatially de-identifying information does not make it de-identified legally. And one of the things that I see in a number of contracts is oftentimes people will allow a vendor to maintain and use de-identified information, but yet the contract doesn't contain any standards for how that information is actually de-identified. And I would tell you that you're really, a couple things there. One is that that's a tremendously valuable asset you've just given to someone, and you should be compensated if you can be. PHI, protected health information, cannot be sold. It is a criminal act to actually sell PHI. You can certainly sell de-identified information, but it has to be properly de-identified to do that. And there are very limited ways in which you can properly de-identify information, and that continues to evolve. So if you give someone the right to de-identify and they don't do it properly and they experience a significant breach, that is going to be on you, because ultimately you're going to likely have to notify your customers and your clients that that occurred, and that is, you know, to say that's awkward is a huge understatement. So really important to understand your place in the chain and understand that just because you yourself are not a health plan or provider, or maybe you're farther on down the chain, doesn't mean that the data that you receive or transmit or have access to is not protected. So I've tried to set the stage for what is protected. Let's talk a little bit about some of the best practices that you can start to implement to really make sure that you're managing this risk appropriately. You know, I'm trying to make it easy to remember. The steps we have are take it to the top. That's the board level, management level. Step 2, assess and manage risk. I have rinse and repeat to be kind of cute, but essentially it's an ongoing process that you constantly have to be updating because the risks are changing all the time. Really important to do some advanced preparation for breach. Really important that you understand how you're contracting, what level of review you're applying, and making sure you're comfortable with that, as well as get the message out to all of your employees. In terms of corporate governance, I think that this was a survey by a Carnegie Mellon survey where they asked corporate boards, does your board review and approve top-level policies on IT, privacy and IT security risks? And nearly half said rarely or never. Does your board review and approve annual budgets for privacy and IT security programs? 54% said rarely or never. And that, I think, is a great indication of what the gap and the opportunity that exists for people to do this a little bit better. I have speak truth to power. I think that it's really really, really important, and I mentioned this actually in my earlier presentation from a compliance standpoint, but I oftentimes see boards who receive information from executives and they, are we set, or, Joe, can you promise me, are we protected here? And there's this inherent level of trust that takes place, or just mere reporting. If you're exercising your fiduciary obligations, you need to test that information with empirical facts and make sure that you understand what breaches have you had, what kinds of attacks are you seeing on your firewalls, what's going on with your IT system. That needs to not be filtered. You need to kind of get some of the granular information to understand where you're at right now. And I think it's really important that boards understand it's okay if they want to engage in very risky behavior, but oftentimes I see the opposite is true, is that they believe that they have little or no risk, and they just take it at the word of the executives that that's the case, and the executives have taken it at the word of several other people down the chain, and there's just not this real sense of, let's just be honest, this is what we want to pay for, and we're going to get what we pay for in this arena. And so I think it's really important, if you have low risk tolerance, that you've dedicated adequate resources to managing to that low level of risk. And if you're not going to dedicate those resources, that's fine. That's not illegal. It's just that your board needs to understand this is what we've got here, and be comfortable and acknowledge and agree that that's what they've decided the position of the company is going to be. And that's a tough conversation, and one that I don't see a lot of executives engaging in, but really, really important, I think, for us as attorneys and counsel to really encourage people to really make sure that they are knowingly choosing not to implement additional measures because maybe it just doesn't make sense given the risk profile. But if you don't know what your risk profile is, or what data you retain, or how you retain it, how are you going to make that judgment? Really important. SEC has been increasingly focused on ensuring for publicly traded companies that there is adequate cybersecurity measures in place. The best way to, I have how to protect the board, really how to protect the organization, is to make sure that the ultimate decision makers have the information and that they've been educated sufficiently in order to make some intelligent decisions about where they want to be on that risk spectrum and what resources are adequate and sufficient to meet their desired level of risk. I think that having security expertise on the board is just like having financial expertise, really, really critically important. That individual can be a tremendous asset to the board in evaluating this issue. I think that understanding how budgets are going to relate back to the level of risk that the organization is taking on, and I think that even board members need to understand what level of training and education is taking place in the organization and whether or not they feel that's significant. I know of a number of larger health systems that now have a dashboard report that goes to the board in terms of the quarterly level or annual level of breaches and security incidents, and the level of attacks on their firewall, so that they can be getting empirical information to assess whether they feel that they have adequately addressed the risks that they have. With that, I want to turn it over to my colleague Justin to talk to you a little bit more about this risk analysis process.
Hi, my name is Justin P. Webb. I'm an associate in the litigation practice and also in the data security and privacy group that we have formed. And so the next step is, how do you assess and manage risk in an enterprise and sort of establish a security framework and monitor that framework as you're moving forward to manage the risk that you have in any company. Before I go to that, I just want to make one comment on what Heather said about protecting board executives. I think one of the most important things when you're giving information to the board or executives at a company is that you have to take the information and rise it from, or lower it from esoteric to real world information. So if you give stats and statistics about this is the number of incidents and this is sort of the security risk that we have in the enterprise, that may not resonate with a board or with an executive. But if you do real world exercises or some other demonstrations to show what those risks can do in the enterprise, that's more likely to get the board or an executive to move on a security initiative or to fund a security initiative. So It's one way to make those security presentations more effective to a board. So the first step sort of in this second step of the framework is to assess and manage risk. So there's many frameworks that are sort of thrown around that you can do this through. There's NIST, there's CIS, which is the Center for Internet Security Controls, and they all really want the same thing from, or look for the same thing in a security enterprise, which is, can you identify where your data is? Are you monitoring that data? Have you implemented security controls to protect that data? And what do you do when a security incident occurs? So that includes an incident response plan and afterwards corrective action, which might include sort of melding with your business continuity plan. For people that are sort of in the healthcare sphere, people may be HIPAA compliant, but that doesn't necessarily mean that you're operating under reasonable security controls. Those are two different things. So you can be HIPAA compliant, but the California Attorney General, who says that the reasonable security controls are based on the CIS security controls, may not think that you're actually have enough security in your enterprise to be reasonable. No matter which framework you choose, you just need to stick to grab a process and stick to it. So essentially, if you choose to use NIST, follow that framework and go through all of the steps to try and get your security up to that level, or if you choose CIS, the same thing. And the most important thing is that security is sort of a journey. You're looking for process and progress, not perfection. And I like to say, especially on the ground level of security, you don't need to outrun the bear. You just need to outrun all the other people that the bear is chasing. And so if a hacker is looking for low-hanging fruit, what you're trying to avoid is you being that low-hanging fruit. So if you take one step above everybody else, it reduces your security risk. And that reduces the chance that you're going to get attacked because they're going to go after sort of the low-hanging fruit first. The other most important thing is to consider the role of the attorney-client privilege in all of this. When you're doing security analyses, if you're contracting with outside vendors, how does the attorney-client privilege fit into this? If you get into litigation about a data breach, and you have all of these reports and information from your information security officer or an outside entity that say your security is lacking in X, Y, and Z, that's obviously not going to look good. If you run those things through an outside entity who does penetration tests and tabletop exercises, then you may be able to cloud it in the attorney-client privilege and protect against sort of throwing a lawsuit right from the beginning. So the first principles are, and this is sort of fits within any of these frameworks that you would choose, are you got to know where your data is. What kind do you have? Do you process credit cards? Do you have healthcare information? Are you a university that has FERPA protected data? And then where is it stored and for how long? So do you have it on a third-party site? Do you store it with like rack space? Is it a local on hard drives? Is it on a managed server? And do you have a document retention policy? I think that's one of the most important things that enterprises either don't do or don't enforce. A lot of them have document retention policies, but if you ask anybody inside an enterprise, they say, yeah, we don't really follow it. And that leaves a lot of potential PII or PHI just sitting around to be accessed, and that obviously increases the attack surface for any enterprise. Who has access and who should have access? Obviously, there should be data segmentation. So every employee in your company shouldn't have access to PII. Only the people that are on a need-to-know basis should have access to that. And then finally, how is it secured? So do you have firewalls? Do you have to log in with a strong password? There's many different ways to secure things, but the most important thing is to know how that data is secured. And once you've sort of established that baseline, you can review and assess the policies and practices for that data. So how do you collect personally identifiable information? If you're an online vendor, obviously you're taking in credit card numbers, and you shouldn't be storing them under PCI, but maybe you are. How do you disclose that information? Do you farm it out to third-party vendors? And what do your contracts look like? How do you protect it in a physical and information security sense. So, and how do you destroy it? This goes back again to the document retention policy. And then scaling down whatever data you have. And this, once again, goes back to the document retention policy. If you remove as much PII as possible from your enterprise, you reduce the attack surface. So if you have PII from 1984 and you're never going to use it again, there should be some method in your enterprise to get rid of that. There are programs like Identity Finder that will go and search an entire enterprise and tell you if you have credit card numbers, PII, login and password, any sort of PHI or PII, and then you can go in and decide, is this necessary, is it not, and get rid of it. And obviously, restricting access sort of goes back into the sort of know your data and how is it secured. Next principles, and this is sort of looking generally at sort of how you implement a security plan in an enterprise. And having worked in information security, I've sort of seen a lot of different teams work together, and you have to have a proactive security plan. If you're just reacting to every incident that occurs or every story you see in the news about a hacking incident, then it turns into a sort of a frantic mess all the time. You need to have reactive information security professionals and teams that are looking ahead to what the next attacks might be, or learning from the mistakes of their peers and sharing information. So one of the most important things when I was at Marquette is there's an information sharing system between all the universities regarding data security incidents. And so if something's happening at another university, it stands to reason that maybe that same attack would work at ours. And so I know they have information sharing entities with banking, with healthcare, and it's important to farm that knowledge. Even the latest cybersecurity executive order has that was recently passed has some sort of strictures about reducing liability if you share information about data security incidents with your peers. The other two things are, if you have an underdeveloped program, avoid and hyper-focus on operational aspects. So if you just have an information security professional and you only have one, obviously that person should be focused on the technical side of things and not spending all their time coming up with metrics and things that don't actually secure you but may make you feel better when you show a bar graph that says, well, we haven't had any incidents in like 1 month. And if the technical ability is lacking, you want to avoid focus on strategic aspects. I think I got those backwards, but if the technical ability is not there, then you want to avoid using all of those graphs and stuff. And if you have the operational things, that you need to be working on the ground for it. I talked earlier about know your attack surface. That is where your data is, the routes to get to it. Do you have VPN access to your data? Do you allow third-party vendors to have your data? What employees have data, where do they store it, all those things. And then establish a baseline. I think this is something that a lot of people sort of forget, but when you have a lot of data and you have different users in an enterprise, knowing what the baseline is. So my computer always looks like this. These are the icons on my desktop. This is the way it looks when I log into a particular place. This is what it normally asks me for. That's the way that you can get buy-in from employees to report incidents where something strange happens. So for example, at Marquette, we had somebody call into the help desk and ask to change the password of one of the professors. And the person had a heavy accent. When they looked up the professor, this person had a name and was in a department where they know that they wouldn't have that accent, and so it was reported as a security incident. And somebody later looked into it, and it was somebody trying to change his password and steal money from the account. And it's seeing that this is the odd or other in that situation that you should be looking for. Or an employee reporting that when they tried to log into their webmail, they got some error message. Well, that could be because they responded to a phishing email, typed in their login and password, and the page didn't actually exist. And those are ways to head off at the pass incidents like that. And I think I've already harped on this point enough, but enforcing record retention policies is very important for reducing your attack surface. So these are sort of next principles. We talked about the cybersecurity frameworks. There's the National Institutes of Standards and the Center for Internet Security, CIS, which is not on here. CIS is actually the framework that the California Attorney General put out guidance for and said, this is what we define as reasonable security measures in California. So if you're located in California or you have data of people in California, that would be the standard that you would want to use. NIST is used by a lot of federal entities like the FTC, SEC, and others to say this is the standard that we want you to have or try and aspire to. And I think it's very hard for any sort of entity to meet every single requirement of these. I mean, there's so many stages and steps, but like I said before, it's sort of progress, not perfection. There's also the HIPAA security rule, and then the Attorney General guidance. California has them, and many other Attorney Generals are starting to follow suit and say, here's what we expect in our state if you're going to store residents of our state's PII or PHI. There's also other frameworks that you can use. The SANS top 10 is like the top 10 vulnerabilities in any enterprise. Same thing with OAuth. And I think the most important about all of these is staying up to date on the security landscape and the frameworks and guidance. So these things tend to change a lot, and lately a lot of federal agencies have been putting out sort of security guidance. The SEC and a bunch of other agencies have said, all right, here's what we expect from people that fall under the guidelines and rules of this particular agency. Heather had talked a little bit earlier about the FTC and their sort of continuing move into regulating data security under sort of the deceptive trade practices. One thing I will say about that is it's a question and remains to be seen what the new administration is going to do with FTC enforcement. It tends to be the case that in a Republican administration they pull back a little bit on the FTC moving into sort of these areas. And the FTC's ability to regulate in this area is also being challenged right now in the 11th Circuit. So there's an entity called LabMD that had this case with the FTC, and right now they're saying that the FTC is exceeding their authority under I think it's Section 5A of the FTC Act. So those are things to keep an eye on, but more and more federal agencies are coming out with guidance on this. This is sort of the ideal world of any security enterprise. You want to have encryption, intrusion detection, and prevention. So encryption just means take data, put it into a form that's unreadable. One important thing about encryption is to know the difference between encryption and encoding. Encoding is something that can be decoded, and it would be like if I said, instead of encryption, it was like F, like one letter above each one of those. You could reverse it and get the same thing again. Encryption, you can't reverse it and get the actual answer. There's also hashing and all this other stuff, but that's a little bit outside the realm of this. Intrusion detection and prevention is how you know if people are trying to get into your enterprise. Prevention is sort of the active role of that. So it's not just telling you people are trying to get in, but it's trying to prevent them from doing that. Mobile device management. What do you allow your employees or clients to have on their phones? What apps can they install? Is there an acceptable use policy for that? Can you remotely wipe it? DLP is data loss prevention, so you can tag documents and know when they leave your enterprise. Skills-based user education. A lot of security professionals and people in the industry talk about user education as sort of this panacea. I disagree. We've tried user education, and I know a lot of people who disagree with that. On the general, like, watch this PowerPoint and listen to this talk and you'll be better at security, I'm not necessarily convinced that that really helps a lot of people, but skills-based education tends to. So PhishMe and other programs like it actually phish employees in your enterprise, and then when they fail, it takes them to a page that explains to them what they did wrong. So it's a real-world example of how they're failing at security. I know a lot of places, this one included, that are using those types of skills-based education. Social media monitoring is another important one. If I was to hack any person's enterprise that sits, that's listening to this presentation right now, the first thing I would do is look up your employees on Facebook and Twitter and see what they're talking about in your enterprise. I'd look at their LinkedIn profiles to see what programs you have in your enterprise. I'd look at your HR listings. So if you're looking to hire a database professional and you say, we have Oracle version 11G database, we have blah, 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 blah. Well, I know exactly what you have in your enterprise, and then all I have to do is try and attack one high-profile target there. So I think it's important to minimize the amount of information that you have that you're putting out onto the internet and watch what your employees are doing. If you have a particular employee who's going online and complaining or accidentally copying passwords to like pastebin, that kind of stuff can go bad real quick. Two-factor authentication on any access, so you want to have something that you know, which is your password, and something that you have, which would be like a phone or a dongle or anything like that. RSA makes little keys. Lockdown firewalls just means you're protecting your exterior. And then internal penetration testing means if you have a big enough security team, you have someone internally who's actually trying to break into your systems. I used to do that for Marquette. And you can glean a lot of information about your security posture when you let someone loose to try and monkey around in your enterprise while not making anything break, obviously. And then the essential policies and procedures, these fit within these frameworks as well. These are the things that you need to sort of define who does what the responsibilities are, and what happens when things go sideways. So an incident response plan says who meets after an incident, what do we do, how does this fit with our business continuity policy and procedure, and essentially what happens when things go bad. The mobile device management policy would fit into the earlier things I spoke about managing how people access your enterprise resources from a mobile device. What do they have access to? What can they store on the phone? Is there a policy about sort of how they can use that to access your enterprise? Employee handbooks are important. That's a place where you can put sort of penalties for violating your data security policy. So you can say, an employee may be fired if they, intentionally disclose PII, or they may be, you can have anything that you want in there. But it's also a place that courts look to when they're trying to assess whether there's a Computer Fraud and Abuse Act violation, which is, did a person exceed authorized access or had no authorized access whatsoever. Acceptable use policy defines what people can do on your network. That's another place where Computer Fraud and Abuse Act violations courts look to. So if it says that only X, Y, and Z have access to this particular area, and you have a warning and that person doesn't have access and goes and gets in, that's obviously exceeding authorized access, and you may have a CFAA claim. Business continuity policy I've talked about before, that's sort of how you get things back up and running after something happens. And then general information security policy would tie this all together. And user agreements is another way to tie employees to the responsibility they have to keep PII and PHI secure in an environment. And there's a note on the bottom of here, just this is all in addition to a HIPAA policy or a HIPAA compliance policy that you may have in an enterprise. All right. So where are the vulnerabilities? This should be easy based on sort of what you hear in the news. In my experience and from many people that I have worked with, employees are normally the #1 set of individuals that will cause problems. So they lose laptops, they accidentally email spreadsheets to people, they get angry and they may put stuff on the internet, or they may just misconfigure a device within your enterprise. It could be an IT employee, it could be anybody. Or they just plug in a device to your network and there's no security on that device whatsoever. Third-party data storage and vendors sort of go hand in hand. Nowadays, a lot of people store personally identifiable information with a third party who processes that data, and then that third party may store that data at another party's sort of server farm. And so you need to know what each of those parties' responsibilities are in relation to your data, because under state data breach laws, if you're just licensing the data for them to use, typically the onus is still on you to make a data breach notification. So you'd want to have contractual provisions, and I think Heather's going to talk about that a little bit more, that protect you in that regard. And then there's problems in your physical environment where you can have vulnerabilities. Misconfigured firewalls and infrastructure, people defacing your web page or getting into your VPN portal, and then endpoints, any device that a user is using that they may lose, or people may, you have a misconfigured printer that's connected to your internet and somebody wants to, have it print out, 11,000 pages and lock that thing up. Or I would like to add to this Internet of Things. So as more connected devices get on a network, and the security of those devices has sort of empirically been shown to be very not so good, those also can cause vulnerabilities in environments. So if you have a network-connected blender and it gets used in a large-scale internet attack, similar to the one that was recently perpetrated that took down a lot of different websites and slowed down the internet in general, that can cause vulnerabilities for your enterprise as well. So the best practices for auditing and testing should always have an outside entity come in and take a look at your systems. Essentially, ethical hacking or penetration testing. So they look at your systems and say, all right, here's where all the vulnerabilities are. Here's what you need to fix. And you really need to have somebody with a hacker mindset coming into your enterprise and looking at it. If you're just running vulnerability scans from the inside, you're not really getting a complete picture. You need somebody who wants to break in and finds it fun to break in, because that's the mentality of somebody who would actually try and break into your network. I've done this as well. It's a lot of fun. But you also, when you're doing this, make sure you're hiring somebody who's reputable, that you're running it through attorney-client privilege, and that the information that they provide to you afterwards is kept confidential and secure. Other ways you can test it are tabletop exercises, which tend to test more your incident response plan and how employees will act if you have a security incident. Vulnerability scanning is just looking for the vulnerabilities, which is different than ethical hacking, which is I find the vulnerability and then I exploit it. Internal and external phishing and spear phishing are just sending malicious emails to employees in your enterprise and seeing if they will click on them or log into fake portals. And spear phishing is a special version of phishing, which is instead of phishing your entire enterprise, I'm going to phish the CEO and all of your employees that have access to PII. And I'm going to do it in a concerted way with something that's sort of almost too hard to resist, and see if they will give up the goods, and if I can access your network in that way. And that is, when I talked about before how I would hack into an enterprise, that's the way that people will go about trying to get into a sophisticated enterprise, is they will aim at high-value targets and then pivot from there. So things that you should keep an eye on. State data breach laws are always changing. One example is Illinois. They have a new data breach law that's going into, or essentially like a revised data breach law that's going into effect January 1st, 2017. And it says a few important things. One, that personally identifiable information includes a person's name and their, so a person's login information. So if I have your login name and it's your email account and the password, that would be a data breach. And it doesn't even need to be that. It can just be your login information and the answer to your security questions. So if I know your login, I hit, I forgot my password, I answer all your security questions, obviously I could take over your account, and that would be a big problem. So that is included within a data breach. The law also requires that all people storing Illinois residents' data have reasonable security measures, which of course the statute doesn't define. So that's left up to each individual entity to determine. And the statute also requires that any contract that you have with a third-party entity has to have a provision in it that says the third-party entity will also use reasonable security measures. So this goes back to sort of the contract issue that has sort of rolled into this, which is, do your contracts have a data breach response provision? So if something happens at a third-party vendor, are they going to tell you immediately that there was a breach? And is there a provision about them using reasonable security measures? And is there a provision about their physical security measures? There's all sorts of things that you can add into contracts. Indemnification provisions. So if they have a breach on their data, if they have a breach on your data, who's going to pay for the notification, the remediation, all of that stuff? And this sort of ties into the changing standard of care, which is being defined by federal entities and state AGs. You should keep an eye on social issues that have an effect on information security. So, for example, Russian hacking during an election, obviously that has an effect on how people are going to approach security. And I always encourage people who have data security teams to keep an eye on the underground. While it is like the dark web, everybody actually has access to it. So your security professionals should be keeping an eye on what data might be being sold on there. They sell a lot of healthcare data, credit card data, all the rest. And now, actually, I have a little bit more to go. So getting ready for a breach, do you have an incident response plan? Do employees know how or when to report data incidents? This goes back to having a baseline. Do they know who to talk to? Do they know what they're looking for that they can identify a breach? So my desktop changed, something happened when I logged in, those kind of things. And consider the interrelationship between a HIPAA data breach policy and an IT incident response procedures. These two things may be different. And lastly, cyber liability insurance. This is the new sort of thing going on here, which may cover you in an incident. And I'll get to that in a second. I'm going to skip over how a data breach occurs. We've sort of talked about that before. And the costs of a data breach are significant if you do have one. There's the investigation, the data breach notification, which costs money. You may get fined by an AG or a governmental entity like the FTC. And it causes reputational damage and lost business revenue. So if you're spending time trying to repair your image, obviously you're not making the money that you would normally do. And people tend not to trust entities that have security incidents. That happened to Target, where they saw a drop in sales after they had their incident, although it seems like people have a short memory for a lot of these things the more and more they happen. And finally, cyber liability insurance. This is a new and burgeoning area. It's probably important for large enterprises that have a lot of PII to look into this. And I think the most important thing here is that you need your information security people to be looking at these policies, because they define what a data breach is in very technical terms. And so if you don't understand what the policy actually covers, you're not going to understand what sort of remuneration you're going to get from this policy or from the insurance company, and sort of what to do in security incidents. You know, does it cover external breaches and internal breaches, or employees that have problems with securing data? What are the exceptions to this? And finally, realize that the norms are being established. Because it's a new area of insurance, I've been told by a lot of people that you can negotiate sort of the provisions in this insurance. So you can have it cover internal breaches also, and it may raise your premium, but there's ways to get this to cover more, and it's important to understand what it does cover. And now I will hand it back over to Heather.
Thanks, Justin. In the last, it looks like we have about 10 minutes left. I wanted to make sure we walk through some of the vendor management and contracting recommendations that I would have. I think that with increasing frequency, we're starting to see more security reps and warranties in client engagement agreements just for counsel. I know our firm has a process for reviewing these, and we do include our information security officer in that process, and I think that's definitely a best practice. I think that many firms may or may not have a well-defined process for entering into business associate agreements with their clients, and I think that's something that's really important that people need to consider how they're going to get that done. The other thing I will tell you with respect to both of these categories of arrangements with counsel is that you will see tremendous variance in the requirements, for example, for reporting a breach, whether it's 10 days, 2 hours, 1 day. So critically important that you have a process for reviewing that and implementing those contracts that you agree to. For purposes of clients, and frankly this is true for law firms as well, really important that you have a process to do some due diligence on your vendors. I think that really a risk-based approach is the only way to get this done. Certainly in larger organizations, you're not going to be able to review as general counsel every single agreement, nor is your security officer, but you do need to have some good training and tools for your business people and people who are going to be soliciting these vendors and vetting these deals up front before they get to you, and also have a process for the security team to review what these agreements are. I think in terms of contracts, I mentioned to you before, really important that you understand whether the vendor is going to collect your information and keep it. I mentioned to you previously that I see many agreements where people are basically losing the value of their data. They're giving it away for free. You see this often in group purchasing organization arrangements with large healthcare clients. You might see it in a variety of billing software programs that people offer. I think that really important that you knowingly give your information over, and if you're going to do it, you need to make sure that you're doing so permissively. So if they're going to de-identify it, you need to make sure that the correct standards are in there. I think that indemnity could be its own session on this topic, but I think oftentimes the indemnity provisions that I see really are maybe an allocation of risk that may or may not be appropriate given the relationship. So I think it's really critical that you think that through in terms of who is in the best position to control the risk which is being indemnified. I think that vendors oftentimes may or may not have cyber liability insurance coverage. And oftentimes I find many organizations think that they have coverage, but they actually have a policy that is extremely limited in scope. And so really important that your broker have expertise in this area. Not every broker really understands these policies well. In fact, I have encountered a number of really good brokers who do have an offering in this regard or will go to market for you for cyber liability insurance, but may not truly understand all the technical ins and outs of what's covered and excluded and what the scope of the policy is and whether those limits are really going to work for your organization. So it's really important you get the right people at the table. The other piece about insurance in terms of contracts is many times insurers, when you have to go through the process of applying for insurance and doing underwriting, you fill out an application. And I can't tell you the number of times that I've seen those applications that have been filed with statements that may or may not reflect the actual current status of someone's security program. And there's case law right now where insurance companies are saying, look, the coverage was negated because they told me they had an effective security compliance program in place and they had nothing, as evidenced by this terrible incident that they're now asking us to cover. So it's really important you kind of think through and draw that thread through the process. I think that the data breach clauses are really important to understand in a vendor agreement. The process and the timing, what cooperation is going to be required during the investigation, who is going to have the right to notify the affected parties. You may not want to give that right up to your vendor. They're your customers and they're going to ultimately look to you. I think that as Justin mentioned, it's really important to specify all of the different types of expenses that you may look to have covered by the contract, and a very clear delineation of responsibility. I wanted to add to this, one of the things that I see in a lot of agreements now are these security addendums that have very stringent, broadly stated security provisions in there that a lot of people don't take the time to look through, and they're like, oh, of course we have a security program, that's got to be fine. And I think it's really important that in terms of your stratifying these agreements by risk, that you really do take a close look at those security addendums or security questionnaires that you're required to fill out. I often see in there provisions that say you agree that upon request you'll provide us with a copy of your security risk analysis. That's a document that you shouldn't be sharing with anyone because it identifies where all your PHI is, all of the threats and vulnerabilities of your system, and what exactly you put in place in terms of controls. You've just given a roadmap to someone to all of the ways in which they could attack your system. Really important that you think through what information is going to be exchanged. What I see now as a really kind of a happy middle ground that you can work with is to say that you'll have a third party provide some type of attestation that you have met certain security requirements on an annual basis, and you'll share that with people. Or you have a vendor or your team prepare a summary of what your security program is and how you put that into place. And that I do not have a problem with sharing, but I don't think you want to be in a position where you're forced to share that very critical information with another party. Last but not least, I want to mention that oftentimes these vendor agreements will say that you'll be in full compliance with all these laws and you'll follow all our policies and procedures. And that's something that gets glossed over. Any compliance program that actually functions well is something that's been fully implemented and sets forth standards of what that organization is going to do, right? I think we can all understand that. Well, how is it that you can follow the policies and procedures of numerous customers or numerous clients and have a functioning compliance system? So I've been involved in a lot of different corporate negotiations where I think that if you walk it through with someone, you can help them understand very quickly why that is not a reasonable provision, and frankly, it's not to the benefit of the party who is seeking to be protected. Because if I have to change my program for everyone I work with, I'm obviously not going to implement something that really I can train everyone to measure and make sure it's effective. And so that's a little nugget I'll offer to you. I think that if you explain to people why it is that you say 4 days, that's what we do. And absent some extreme circumstance, we need to make sure that that's how our program works, that's how we can get it done. We will give you everything in 4 days, not 2. And if you walk it through with them, oftentimes I think you'll have more success. Last but not least, in terms of training, I think that Justin has really covered this, and I think that really important that the training you're providing is meaningful. So it's not just educating people about the importance of passwords, but what Justin mentioned is making sure it's real for them. I think one of the most important things is a well understood and publicized reporting procedures. So people know who to go to when there's a problem and how that's going to work. And I am always surprised when you find out after the fact that someone knew something went wrong, but they didn't think it was a big deal or didn't have any idea that they should have reported it. So don't miss that easy, low-hanging fruit in terms of your cybersecurity risk management. Make sure that people understand who to go to and when they need to go to someone and raise their hand that they saw something strange. I can tell you, for example, at our firm, our employees have been trained that if anything looks off or they're having a weird problem with their computer system, they need to alert our help desk right away. Or if they receive strange emails or emails that look like they're phishing expeditions, people are supposed to be forwarding that to our help desk so that they can track these things coming in and perhaps send an alert wider to the firm so that people are aware of it. And I think that real-time engagement really has made a difference for our firm, and I would advise that to everyone. Last but not least, really important that you train people, your employees, to avoid having in their possession PII and PHI unless it's absolutely necessary. That, again, very simple to say, harder to do if you haven't trained people about the ways in which they can do that and still work effectively within your business. And so I think that that's a communication you need to have with your clients, your customers, and make sure everyone's aware that y'all need to be in it together in order to really make this effective. We are at the end now. I don't know if anyone in this room has any questions. I hope this has been helpful for you. Any questions, Nancy? Did you guys have any questions? No. All right. What is the appropriate role for a security consultant, and are there things to look for? What types of engagements should be privileged? I think Justin did touch on this a little bit. I think any engagement where someone is going to be assessing the vulnerabilities of your system and what current controls that you have in place is something that you should consider privileged. I oftentimes have been been the recipient of these reports from consultants after the fact. And consultants are just doing their job and getting through the day, and oftentimes they'll say things that to a third party who is not looking to interpret it in the most favorable light to you, will say things like, you have a huge, unpatched gap in this firewall, or you have no protections in this, or you lack controls in this area. A lot of times when those reports are first prepared, there hasn't been the exchange of information back and forth where people can say, well, actually, so-and-so was out that day. They didn't tell you that we have these 12 controls in place. So it may not even be accurate. If you don't protect that document with privilege, it could be discoverable later on. And that has been something that's come into play in some of these lawsuits where insurance companies have challenged coverage and or where people are seeking to initiate class action lawsuits against an organization for their lack of security controls. So really important that you don't let that horse out of the barn if you don't need to. You could always waive the privilege later if you want to. You just can't retroactively invoke it, as you all know. So that would be my advice on that. I think we're at time. Thank you very much for your time. I hope that was helpful.